This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why litigation between insurers should be avoided and why only a potential for coverage is enough to require an insurer to defend. And in my opinion, liability insurers should work together for the benefit of the mutual insured rather than litigating against each other on a questionable issue of coverage. When two or more insurance companies issue policies with the potential for coverage of a claim of bodily injury, they should work together to protect their mutual insured rather than litigate with the insured and the other insurers. Litigation is expensive and may result in a case and a decision that they really didn't wish to have. In Admiral versus Track Group, Inc. and certain underwriters at Lloyd's, the Court of Appeals of Illinois on March 27, 2024, looked to protect the interests of the insured other than the interest of the insurers when interpreting the policy. The appeal concerned an insurance coverage dispute between a general liability carrier and a professional liability carrier. Certain underwriters at Lloyd's and Admiral Insurance Company both insured Track Group, a company in the business of electronically monitoring individuals using ankle monitors. Track Group was sued after a person wearing an ankle monitor sustained severe injuries while driving his vehicle. Underwriters had paid the cost of Track Group's defense up to the time of the Court of Appeals decision, but it argued that Admiral should share in the cost as it believes both insurance policies provided coverage in this case. The Circuit Court held that Admiral did not owe coverage under the terms of the insurance policy, and the underwriters appealed to the Court of Appeal. Underwriters had issued Track Group a general liability insurance policy, while Admiral issued a professional liability insurance policy. Track Group sought coverage under both policies in connection with a personal injury lawsuit filed against it in Los Angeles, California. The plaintiff in that suit, Jeffrey Mohamed Abed, alleged that his leg was torn from his body after his foot, on which he was wearing the ankle monitor, became lodged between the gas and brake pedals in the vehicle he was driving. Admiral denied coverage and filed a declaratory action contending that it does not owe coverage under the circumstances because of an exclusion in its policy. The Circuit Court granted Admiral's motion for summary judgment and denied Underwriters' motion for summary judgment. On appeal, Underwriters argued that the Circuit Court erred in granting summary judgment in favor of Admiral, contending that the Court's interpretation of the Admiral policy was overly narrow. Underwriters argued that the Admiral policy covers the injury at issue, where policy language is susceptible to more than one reasonable interpretation, is considered ambiguous and will be construed strictly against the insurer. Courts construe the policy as a whole, giving effect to each provision where possible because the court must assume that the provision was intended to serve a purpose. According to the plain language of the policy, Admiral is potentially liable for wrongful acts arising out of the provision of professional services and technology products. The policy includes a general exclusion for bodily injury and property damage, but the exclusion does not apply to bodily injury arising out of the provision of professional services. In other words, Admiral's policy could potentially cover bodily injury arising out of the provision of professional services. And one of the four components of the ankle monitor is an internal central processing unit. That means that the ankle monitor can make and receive calls, generate alarms, receive radio frequency transmissions, and communicate movements to Track Group. Because the ankle monitor is an electronic device that can store, retrieve, and process data, it is potentially a computer. Moreover, the ankle monitor likely constitutes hardware because the ankle monitor is potentially computer hardware that monitors the actions of Mr. Abed. The Court of Appeals held that, therefore, it potentially covered by Admiral's policy, and potential coverage is really all that is required to trigger an insurer's duty to defend its insured. Because the facts of Abed's lawsuit against Track Group potentially fell within the terms of the policy, the decision of the Circuit Court was reversed. In my opinion, the court did what the insurer should have done. It read the policy, which covered claims resulting from professional services or technology products, exactly what was alleged to have caused the injury to Mr. Abed. Since the ankle monitor was clearly a technology product and was claimed to be the cause of the injury that ripped off Mr. Abed's leg, there was a potential for coverage, and all of the insurers owed Track Group a defense. Working together, both insurers should have and could have saved money and served their insured fairly and completely. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll have access to the more than 4,750 blog postings. Please tell your friends and colleagues about this blog and the videos and let them subscribe. It's free. And if you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for the very small fee of $50 a year, subscribing to my Substack publication. Thank you for your attention.